Hello friends, welcome once again to the Supreme Court Historian YouTube channel. Yes, the channel is active and yes, I am here to apologize upfront about the massive delay between these videos. These past few months it has been now since I last made a video, and I really do apologize for it. I'm sorry. Too many things happening in my life. My life is not supposed to be this happening at this stage of at this age really, and so lots of things happening including illnesses, so I have not been able to get back to this delightful hobby of mine, which is discussing the landmark judgments of the Supreme Court. We are looking at the right to equality, and we are making this chronology based on that. We have already looked at the concept of equality in the previous video, and we are dealing with the Kathi Running Rawat case, for which we have to look at two precedents which we have skipped in our chronological journey through the important judgments given by the Supreme Court of India. So in this video I'm going to look at the first of these two, the Chiranjit Lal case decided by the Supreme Court on the 4th of December 1950. That is right, we are going back in the past, almost 2 years flashback. And in the next video we'll look at the Balsara case, which was decided in May 1951. So both of these were referred to in the Rawat case, and that is why we are looking at these two cases right now. And as I have mentioned earlier, I deliberately skipped these cases when we were going chronologically. Now that we have arrived at Rawat's case in our chronology, it is time to look at these two past judgments which dealt with the right to equality. The first is the Chiranjit Lal Chowdhuri versus the Union of India. The case involves a nationalization of a particular company. The company name is Sholapur Spinning and Weaving Company Limited. Sholapur is very famous for its textiles. Sholapur Chadar, or Chadar as we call it in Marathi, those are quite well known, and these were deemed to be essential commodities. This is just after the Second World War, just after independence has been gained, and at this juncture it was found that this Sholapur Spinning and Weaving Company was shutting down due to disputes between the management and the employees or the workers. This notice was given by the company management and the company was duly closed in August 1949, after which, in response to which, the government of India promulgated an ordinance which allowed for the government to take over the control and the management of the company. What does that really imply? Taking over the management of a company, it means that the previous directors, the existing directors, are removed from the board and the government appointed certain individuals as directors, and all the shareholders of the company that existed before this, they were stopped, prohibited from making any decisions, taking any decisions, or appointing any further directors to the company's board. So the company effectively became a public sector enterprise. That is what it ultimately amounts to. This was done through an ordinance promulgated by the Governor General in January 1950. So just before the Republic Day, obviously, and later on the Provisional Parliament in April converted that ordinance to an Act of Parliament, the Sholapur Spinning and Weaving Company Emergency Provisions Act. The case arises from the fact that one of the shareholders of the original Sholapur Spinning and Weaving Company Limited, Mr. Chiranjit Lal Chowdhury, he approached the Supreme Court. He petitioned under Article 32 for a writ of mandamus. Mandamus, as we have discussed, implies that the judiciary can order a government authority, a state body, a state entity, to perform its duties, to perform particular functions that it is supposed to perform. And the writ here was pursued for two specific violations claimed by Mr. Chiranjit Lal, that his right to property under Article 31 and 19(1)(f) was violated by the ordinance and then by the succeeding act, and also his right to equality under Article 14 was violated. Now, the right to property violation is rather obvious. His property, he was a shareholder, so he was a part owner of the company, and that company was taken over by the government without any compensation. So that was, of course, deprivation of his property and hence violation of his right under Articles 31 and 19(1)(f). As you are aware, Articles 31 and 19(1)(f) no longer exist in our constitution, and anyway our discussion is not relevant to the right to property. So we are going to skip that part and move directly to the right to equality under Article 14. How is the right to equality violated when the government takes over a particular company? The violation, according to Chiranjit Lal, was that his company was singled out and its shareholders were deprived of their right to manage their own affairs. Other textile mills in the country that were in a similar situation were not meted out the same treatment by the government. The argument being that the Sholapur company was not the only one that was going out of business or was shutting down because of disputes between the management and the employees. Chiranjit Lal claimed that his company was for some reason singled out, and thus it was a discriminatory action to pass an ordinance for one specific company and then to convert that ordinance into an actual enactment targeted towards one particular company. That is the argument here by Chiranjit Lal, that his company was singled out and it was thus a discriminatory ordinance followed by a discriminatory enactment, and thus violating the right to equality. On the face of it, it is a quite good argument. There is no doubt, nobody is claiming that the enactment was aimed at anybody other than that one single company. Other companies were not under the purview of the ordinance followed by the enactment. So there discrimination? Undoubtedly there is. But as we have discussed, discrimination on its own might not necessarily result in the violation of the right to equality. For example, the one we discussed earlier, that the right to vote is available only after we have turned 18 years of age. The right to enter into a contract is only available after we have turned 18 years of age, not before that. Is that discriminatory? Of course it is. But is that a violation of the right to equality? No, because this particular discrimination is actually protecting those below the age of 18 from being exploited, from being unduly influenced, from being coerced into voting in a particular direction or into entering into a contract which they might not understand is actually harmful to them and not beneficial to them. So there are countless such examples of discrimination. The factor to be determined by the court is whether this discrimination is undue or whether it is justifiable. If it is justifiable, what are the grounds for justification? Unfortunately for Chiranjit Lal, his argument that other textile mills in the country were in a similar situation and they had not been taken over by the government was not backed with any evidence. There was no list of such similar textile mills in a similar situation that he could have led into evidence. Chiranjit Lal and his legal team simply made the argument in thin air. They kind of pulled it out of thin air and they did not really back it with any instances, any concrete instances where this had happened. And in the absence of that, the court did the right thing, that by following a principle which has been in place in constitutional jurisprudence, that the presumption is always in the favor of the legislature. It is presumed that the legislature knows what it is doing. It is presumed that the legislature knows what the people it represents want. And therefore, unless something concrete is led against that presumption, the court has no alternative but to agree with whatever the enactment has been put in place by the legislature. In this particular case, the property argument, the right to property, was thrown out as well by the court. But as I said, we are focusing only on the equality argument, and the bench, just for our benefit, I've listed it out, held that even one corporation or even one group of persons, and indeed even one single individual, can be taken as a class by itself for the purpose of legislation. So we can discriminate between classes of people. That is accepted. The argument Chiranjit Lal was making was that it was one single entity which was acted upon by that enactment, and that does not constitute a class. But the court held that even one single entity or one group of persons, in this case the shareholders of the company, can be taken as a class by itself. So it's not just that everybody under the age of 18 are discriminated against, so it is allowed. That is not necessarily the only way such a discrimination can be found to be valid. It can be held valid for other reasons as well, including if it's just one single entity. Especially, the court said that when a corporation is engaged in the production of a vitally essential commodity, cotton textiles in this particular case, then it has a social character of its own. It comes with its own responsibilities, with its own restrictions, with its own limitations, with its own responsibilities. And if such a corporation is about to collapse through sheer perversity of the controlling authority, and not for economic reasons, but because of mismanagement or because of some problems between the management and the employees, then the legislature has the authority to treat such a corporation which has a social character and which is involved in the production of a vitally essential commodity and which provides employment to scores of individuals. Then the legislature can treat it as a class by itself, and that is the crucial part of the ratio of this particular case. What constitutes a class? Is there some minimum number that at least 10 people or at least 100 people have to be affected by that legislation? Only then can it be a reasonable and valid discrimination? No, no such thing. Even a single entity can be held to be a class by the legislature. So imposing the right to equality is not quite as straightforward as the words in Article 14 make us believe. So that is the first of our cases in preparation for the Rawat case. The second one, the Balsara case, I'll deal with in the next video. I promise you that. Till then, take care. Bye-bye.